It's a really kind introduction, and thanks all for coming. I know this is a busy time of the term, and I appreciate you taking the time. So this is what I'm going to talk about. I know that we have limited time, so what I want to do is just expose you to the core concepts of the book and run you through two case studies. I will allude to the other case studies that I have in the book, and then I want to say a little bit about global capitalism, or how we code capital for the globe. I want to say a few words about the master coders, the lawyers who are basically the who's done it, and I want to close with some questions, perhaps fewer answers than you would want to have on what we could do about it. So the famous Leninist question, "Что делать?" will come up at the end. Okay, so here's the core argument. I'm of course asking in the book, first of all, the question once more, what is capital? And I basically use a definition that has been used by others, Piketty, etc., who are saying that capital has the interesting quality of being able to generate wealth. So it's an asset that has a particular type of quality. People can generate private wealth and maybe also protect past gains with capital. And so the question for me then was, what are the kind of qualities that an asset has to have to generate wealth? And I'm basically saying you need a set of priorities that law can bestow on an asset. And these qualities or attributes are priority, durability, universality, and convertibility. I'm basically saying you need 3 out of 4, and let me just say a few words about this. So the first thing is priority basically means that somebody has stronger rights to an asset than everybody else. The easiest institution to think about in that context is property rights, right? So you have property rights, which basically means that you can decide what to do with an asset, whether to destroy it or transfer it, and to exclude others from that asset. And the priority quality comes out most clearly when you think about an insolvency situation. Insolvency is defined by the fact that the debtor has fewer assets than claims against his assets. So it really, really matters when you have a defaulting counterparty whether you have stronger rights or weaker rights, whether you have priority or not. If you have an owner of an asset, you can take it out. If you have a secured claim, you can separately enforce against the asset that has been secured. If you're an unsecured creditor, you will just have to deal with the leftovers. You'd get a haircut, as we say in jargon. So priority is critical, and legal institutions create ranks and prioritize some claims over others. The second aspect that you need as capital, you need some durability. So if an asset can end up easily on the auction block all the time, the ability to accumulate wealth over time is limited. So durability basically protects assets or asset pools from too many counterclaims, right? It's a particular legal privilege which is bestowed particularly by institutions such as the trust or the corporate law, and I'll go into those details in a second. The third attribute is universality, namely that these priority rights and the durability are enforced not only against another party with whom you might have negotiated these interests, but against the world. Ergo omnes, as we like to say in Latinese as lawyers. It has a universal quality because there is an authority behind that will enforce these attributes against the world, against anybody. Others will have to yield. And then last but not least, especially for financial assets, we need convertibility. You could also think about convertibility giving financial assets durability. Convertibility is not just that I can assign an asset to somebody else, not just about transfer. It's about a right, ideally a right or an option to flip one asset into another one, to get a safer asset for what I have. To have access to cash in times of crisis is really what it boils down to. And that's also why I said you can attain durability for financial assets by having access, for example, to central bank liquidity, or by getting a bailout, or by having maybe a put option to a private party that has a bigger balance sheet than yourself. So basically you need priority, durability, universality, but for financial assets I would say convertibility is the mechanism by which you attain durability. So what fascinated me and why I wrote this book is that I was engaged in trying to understand the 2008 financial crisis and trying to understand the legal tools that had been used before that to create these really, really fancy financial assets like derivatives, the credit derivatives, the CDOs and the CDSs, and of course securitization itself. And when you do an institutional autopsy of these assets, you find these institutions, right? And they're old. They're much older than our fancy financial institutions or assets today. So property law, collateral law, trust law, corporate law, bankruptcy law, and contract law are the tools from which the contemporary financial markets have been made. And when you trace them back in history, you find that many other capital assets have been coded in these institutions. So it starts with property rights and it starts with land. But the same kind of mechanisms that we first used to create to flip land into a capital assets have been used to flip other types of assets, debt or firms or knowledge or perhaps even data, we'll talk about this, into capital assets as well. And that's then basically the story I'm telling in the book, is how these different assets have been coded in law. So the question I still have to answer before we can go into the details is, why law? Why do you need law for all of this? What is the function that law or a state and its laws play? And I'm basically adopting here a Weberian notion of the state, if you want. It's really, what I'm saying is what you need to convert a simple asset into a capital asset is you need a credible commitment of enforceability. You want to make sure that you can enforce your rights at some future date, in some place, and maybe even in some place outside your own jurisdiction. That's what it's all about. So we need to have the institutionalization of the centralized means of coercion that private parties can use to organize their private affairs so that they can bank on enforceability. So at some level, at every stage in the creation of capital and the creation of financial markets, I would say in the creation of markets in general, the state is deeply involved, certainly when we talk about modern states. So when people think about the state and the state law, I think most of them have an idea of a vertical relationship where you have the state and the law dictates what you can do or cannot do. Criminal law says you can't do X, or regulation says you can't do other things, otherwise you will be fined, sometimes also prescribing what specifically people have to do. There's also the flip side of this vertical dimension is that countries that use the rule of law, have a constitutional system, actually empower individuals to use the law against the state, to use the law and the state against the state itself through civil and political rights, right? You can protect your property rights against the state. If you are expropriated, you can get compensation. That's also just to think about is I think it's an enormous institutional revolution to create basically the centralization of the means of coercion on the one hand, but then also allow individuals to avail themselves of that against the state itself. These two dimensions I largely ignore in the book. I'm mostly interested in the third dimension. I'm interested in how private parties can use the coercive power of the state to organize their own private affairs. That's what the book is all about. And the ability to create assets that have priority rights that will be universally enforced, not only against my contracting parties, but against anybody, whether or not they knew about the arrangement or were party to the deal. That's what state power basically does. Okay, so the stories I tell in the book are basically dealing with 4 out of the 5 assets I have at the blackboard here. I talk about land, firms, debt, and know-how, and I thought today I will just talk about land and debt and draw some connections between them so you can see how these institutions work. My latest project is data. Data, as some people say, is the new oil, and it's certainly an asset of enormous monetary value, but it defies some of the characteristica that the other assets have. And so it's an interesting new project for me to think about. So I will just leave this aside. I just want to flag this. This is really cutting edge new stuff here. Okay. I can skip this slide really. This is just to say that the different, okay, so maybe let me just use 2 minutes about these different institutions. So these assets I talked about, land, debt, firms, know-how, can be coded as capital by using the legal institution I mentioned before: property, collateral, trust, corporate bankruptcy, contract law. Now, most of you will have an idea what property rights are. I just want to flag that the concept of property rights for lawyers is somewhat different than for economists. For lawyers, we're thinking about property as an absolute right that is backed by a state that actually creates this rank order hierarchy, right? It's not so much the residual right, the leftover after you have contract out all the other specific commitment to an asset, but it's sort of at the beginning, basically, there is property, and that basically means ranking. The next institution, collateral law, is basically a subset of property rights. You get a particular interest in a thing or in a particular right that is at your disposal when you want to enforce. So think about a homeowner that wants to get a loan. The mortgage is a collateral or a secured interest, and a bank can take the house away from a debtor that fails on to perform on the loan. And so you have a security interest, which is a kind of a small little property right. It's not full property right, but if the debtor defaults, you can actually seize the asset and get a title from a court to enforce against it. Trust is an institution that is perhaps least understood of the ones that I have here in the PowerPoint. So a trust, I think, is one of the most ingenious institutions for coding capital. It comes out of the English common law. And it's a contractual device to create property rights or to alter property rights, which is why the civil law systems don't really like it, because they have a much stricter, a much stricter, I thought I had done, don't disturb, didn't work. So the civil law creates a much stricter separation between contract and property. Just to give you an idea what the trust does, think of a landowner in feudal England where you had primogeniture rules that required the father to leave all his assets to the firstborn son. No wills, no basically private decision where you want to give your assets, you have to give it to your firstborn son. But you do have a secondborn son or maybe a daughter to whom you want to leave some assets. So what do? So you have to get around the restrictions of the inheritance law. And what you do is basically, let's assume I'm the father, I basically say, I'm going to transfer formal title to a certain piece of land that I own to my younger cousin, who hopefully will survive me, right? So I transfer formal title. This cousin now becomes the trustee, but he only has formal title. He doesn't get the economic benefits of the land. The economic benefits of the land shall accrue to my daughter upon my death. That's the deed I draw up, and we put it into the drawer of my country solicitor, and once I die, somebody will discover the deed and say, actually, this land doesn't belong to the firstborn son, but it belongs to the daughter. This arrangement has the other beautiful effect that if I'm still working on the land, I've transferred formal title, but nothing else happens in the world. Nobody can see that. It's just in the documents. My personal creditors come and want to enforce against my assets. I can say, you can't take this land because I no longer own it. Right? My cousin owns it. If the personal creditors of the cousin come and say, I want to enforce against your assets because you didn't pay, he can say, I have formal title to this, but I don't benefit from the economic stuff, so you can't enforce against it. And when the personal creditors of my daughter come and want to enforce against her assets, she can say, well, I don't have it yet. Right? So this is the perfect incubator. You just have created a legal shell that protects these assets from multiple groups of creditors and thereby can grow over time. Things have become legally a little bit more complicated over time, but the trust is the core institution today still to have these family offices to protect private wealth from taxes and private creditors. It's also very important in securitization structures, and I'll come back to that as well. Did this go out? It did go out. Doesn't matter. Let me just talk through it. It's bad. Okay. Let's just ignore it. I'll just talk you through this. Maybe if it comes back up before we get to the debt. But for the land, I can just talk you through it. So when you go back to the 16th century, I can use actually this slide. When you look at this slide, you can see that until well into the 19th century in England, rural land, agricultural land, was the most important source of wealth, right? And of course, it starts here. It starts around 1700. You can go a little earlier. In the 16th century already, most of the land that had been commonly owned or used by the commoners and the landlords according to certain use practices was enclosed, and the landlords won a battle, both a physical battle in the field and a legal battle in the courts, to get priority rights to this land, to have their rights recognized as being able to say, actually, we want to close the land against the commoners when we want to build new hedges and new fences so we can use the land to herd sheep or to grow cash crops for the cities and exclude the commoners from that. This was a battle that wasn't resolved by a single piece of legislation, but by hundreds and hundreds of court cases that were battled out one by one, where basically the landlords at some point said the commoners could not use the land anymore. They built a new fence, the commoners broke down the fence, broke down the hedges, they ended up in court. The court cases went back and forth, but all told, by the end of the 16th century, about 2/3 of arable land in England had been enclosed by courts, basically recognizing the landlords as having priority rights and being able to exclude others. Now the landlords, once they had enclosed the land, of course, also realized that they could now mortgage it, so they could get funds to do commercial ventures in London and other cities. But they also then had to learn that once they didn't pay their loans, the creditors could come and seize the land. So they went to the lawyers to get help. And the lawyers advised them that they could protect their family wealth from creditors by basically creating a trust. They called it an entail, but it works exactly like I told you the trust worked before. They basically said the family member, the son, the eldest son that now manages this family business or family estate, is not the true owner. He just holds as a trustee, basically, as a life tenant, the land on behalf of future generations. So the creditors can't take the land away from him because it's not really his land, it's the family's land, including unborn generations, which means that even secured creditors can seize only 50% of the land and can never get the family mansion. So again, you protect your assets from too many creditors, right? And they've been able to do this over the course of the 18th century. The system lasted until 1881. That's why the slide is so beautiful. This is from Piketty's book from 2014, right? And he has this chapter on the metamorphosis of capital and says, you know, the stuff that is the source of wealth has changed over time, and he gives sort of standard explanations of supply and demand and technological shift. And what I'm saying basically here, something really important happened here in England. And this was basically after the system blew up. It's of course inefficient, as you can imagine. In 1870, you had a major depression in agriculture because the landlords would not get another credit anymore from their creditors to roll over old debt, because at some point they just stopped doing that. And they stopped doing this is when English agriculture became really not uncompetitive vis-a-vis North America. They had repealed the Corn Law. So this all blew up in the 1870s. In 1881, two important reforms were introduced in England that had been waiting for decades. The Land Settlement Act and the Land Conveyance Act basically said from now on we treat the life tenant, the firstborn son, as a true owner. We treat land like chattel, and we will enforce. And as a result, over 20% of land was reallocated within a relatively short period of time in England. It was one of the most encompassive land reallocations in England. That happened exactly there. That's when land, in my language, got stripped of durability. Right? You still have priority rights, you still have land, but you no longer have the benefit of the entail or of a trust type of protection, so the land can easily end up on the auction block and then will be redistributed. And if you have these kind of rules, then the ability to accumulate enormous amounts of wealth over long stretches of time is just much more limited, because there are economic cycles, there is competition, and things will be reallocated eventually. So the story of what is interesting when you look at the US, similar picture also from Piketty, the story is a little bit different. And this is, I think, just interesting for political economy reasons. In North America, England introduced the reforms that they introduced in England only in 1881, 150 years earlier. So it's not that they didn't know what to do, how the institutions would work. It's really a story of the political economy. So in 1732, they introduced the so-called Debt Recovery Act in colonial North America, which basically said the same thing. We will treat the tenants or holders of the estates as owners, and we will evict you if you don't pay your debt. And of course, in that case, the English were the creditors and wanted to have access to family estates. They busted a lot of the southern estates, and you also actually had, one of the effects of that was that you had the first slave auctions, because slaves had been taken as collateral and were put on the auction block along with the houses. So story here is that land was not always propertized in that fashion. Land can have all kinds of different arrangements, but it started in England in the 16th century, and other countries followed suit later on. Creating individual property rights on land took time. It took several centuries. Only in 1881 did England introduce a registration system for land, and it made it mandatory only in 1925, so really late. Just keep this in mind. So priority rights are important, but equally important, and that's so often forgotten, especially in the development debates with De Soto and others who say just title the land, give people title, then they can lift themselves out of property. Durability is really key, and durability does a lot of the work. And durability is basically a legal subsidy, right? It's basically saying we allow you, the state allows you to protect your property from too many creditors, and if you can avail yourselves of these protections without even having to ask anybody, because you have a good lawyer who knows how to do that, then you can basically make use of that particular subsidy. Okay. Let me jump to this, and I'll just gonna do this again so we can see. Whoops. Let me jump to this. So I'm now going to shift from land to debt, which is of course always related. And of course I'm starting here with these little buildings in the corner here. This is houses again, ownership, land ownership and houses. And these are homeowners in California who wanted to have loans and had to grant the creditor a mortgage to get the loans, right? And so we're talking about the securitization of mortgages in the US in the run-up to the 2008 crisis. And on top of that, I also show you basically how a collateralized debt obligation basically works. And what I want to show you is that the same institutions that we talked about for land earlier, just pure agricultural land, work here and how they work here. So you start with these homeowners who want to buy land, or they're being told actually they can buy houses really cheaply, and you have a mortgage originator, which is New Century. And New Century is basically only originates mortgages, gives the loan, gets the mortgage, piles it all up, and then sells it wholesale to one of the big banks, in this case to Citigroup. We're starting in California. Land law is local, no? It's state law, it's California land law, but we're selling the stuff, the loans backed by mortgages to a New York-based major entity, Citi, which has a specific affiliate, one of its subsidiaries, which buys the stuff, thousands of mortgages, puts them together. And what do they do with this? They throw this into a trust, right? And what is the trust under English law? Why? Because they want to make sure that the assets, the cash flows that come from the loans, which are backed by the houses, are separate, distinct from any risk associated with Citi or its affiliates. You want to make them bankruptcy remote. And to do this, you have to basically say this is a true sale. By basically throwing these assets into a different legal shell, this trust, we're really transferring them into this thing. And now the investors, these are the beneficiaries in the trust scenarios, these are all the daughters, the investors who are buying interest in the trust, they only have to worry about the cash flow from the assets in the trust. They don't have to worry about whether Citigroup or its affiliates will go bust, right? So again, you insulate these assets. They can incubate without any other credit risk, and the investors only have to think about the quality of the assets in the pool. There's then always a trustee, like my younger cousin has to be there. This would be basically somebody from JP Morgan Chase who just is the trustee for the Citigroup stuff, and then Citigroup will be the trustee for the same stuff that JP Morgan Chase does as well. What I wanted to look at here is a little bit more the different investors that you have. So securitization of mortgages in the United States started in the early 1970s. After in 1968, the Federal Housing Act was changed, and the government-sponsored entities, Fannie Mae in particular, Freddie Mac wasn't around yet, but Ginnie Mae as well, were authorized to securitize mortgages. Not to originate mortgages, but to buy them on the secondary market and securitize them in order to lower the cost of credit, because you diversify the risk associated with mortgages, and thereby make home ownership affordable. background, burning cities in the United States, many people trying to get houses, couldn't afford them, etc., etc. So the choice made in 1968 in this country was to say we resolve the housing problem by making credit cheap. And the way to do this is to securitize. When Ginnie Mae and Fannie Mae did the securitization, they did a very simple securitization. You throw stuff into a trust, and the beneficiaries all buy an interest in the trust that has the same cross-section. Just a little bit more, a little less. Bigger pie, slice of the pie, smaller slice of the pie. When the private sector joined the securitization game, they discovered that they could actually interest many more different types of investors if they cut and slice the pie in a different way. And so they introduced tranching. The French word trancher is to cut. And what they did is they created cash flow rights that were stronger than others. So this is priority, now done with contract law. Everybody who buys an interest in this trust now knows some have a senior interest. They will always get the first cash flow that comes in. They will always be the last one to face any losses. Then there are juniors who are exactly the opposite. They will always be the last to get cash flow and always be the first ones to bite the losses. And then you have different levels of mezzanine tranches. So you know some people really want to have safe assets, so Fannie Mae now buys the stuff rather than doing the securitization itself. It buys the senior, it wants to be safe. China Investment Corporation, the Chinese sovereign wealth fund, buys senior. Bayerische Landesbank, the German state-owned bank, buys senior. So does BNP Paribas in this example. Okay, so it might be different in some other examples. The junior tranche went, in this particular case, to Citi itself. This happened actually, unfortunately, too often because they thought they could do a nice private placement later on or benefit from the returns. And of course, they got stuck with the junior when the whole thing blew up. The real problem for keeping the securitization machine running were the lower mezzanine tranches, because you had to place all the tranches to basically close the securitization, move to the next. And they did when you talk to the lawyers, they sometimes did 40 structures like that in a week in the heydays of securitization. This was a mass market. You had to produce mortgages, you had to put them through the system, and you had to place everything. But you couldn't really place the lower mezzanines because they were too risky for the safe investors, and they were not risky enough for those searching for higher yield at the lower end. Sorry about that, I'm gonna close this down. And so what they had to do is the industry basically had to produce its own buyers. And that's when I come to the CDO on the right here. So when you can't place the lower mezzanine, you basically set up a corporate shell, in this case in the Cayman Islands. So that gives you additional tax benefit because Cayman Islands is a tax haven. What I didn't show you here is that actually the CDO had a twin in Delaware, the same name, just the Delaware Corporation, because, and they co-issued the interest that investors would buy, because some investors, such as insurance companies, can only invest a certain proportion of their portfolio in foreign assets, and Cayman is foreign. But if they co-issued with the Delaware company, all of a sudden it was domestic. It's another legal trick the lawyers came up with, so that they could attract investors who otherwise would have been constrained. So you set up the shell company. The shell company raises funds from investors by saying, we will now buy a gazillion different lower mezzanine tranches from different securitization structures. Since we diversify, the probability that all of them will tank at the same time is sufficiently low that all of a sudden we can rate them in such a way that we can get senior, AAA, maybe not AAA, but at least AA rated senior tranches, and then upper mezzanine tranches, lower mezzanine tranches, junior tranches, and the investors buy the stuff, you take the money, and then you buy the assets, you throw them, in this case, in behind a corporate shell. And then you might get this stuck, of course, again with the lower mezzanine tranches. And if you do, you just have to go through this again. You just set up another entity, and then we call this a CDO squared. And if you have to do it again, then you do a CDO cubed. That's basically what, in the end, blew up our system. So these are just two illustrations of how this works. I think what you can see here, it's property law, it's contract law, it's collateral law, it's trust law, it's corporate law. There's a story for bankruptcy law that I will spare you because it's going to get too complicated, but I invite you to ask me later on. But bankruptcy law is implicitly in here as well. Let me perhaps say a couple of words about the other topics I wanted to talk about. One is globalization. Okay, we clearly live in a world of global capital. Nobody doubts that. The story that I tell you at first glance conflicts with the notion of a global capitalist system, because I'm saying capital is coded in law, and the legal institutions that I discussed are all institutions of domestic law. There is no equivalent for this stuff at the global level. We have a UN sales convention, but that's just minor. We don't have a global state, we don't have global law. So how can a global capitalist system exist? And the answer I give in the book to this question is, well, in theory, we could have a global capitalist system that is sustained by a single domestic legal system, as long as all other states recognize and enforce the legal institutions that are created under that system, right? So if they say, we accept what you do, we accept everything, the trust, the property law, all the devices that you use under certain law, then you can do it. And I'm basically saying, in fact, we have two, not one, but two legal systems that sustain global capitalism. And these are the laws of England and of the state of New York. And for corporate law, you can throw in Delaware if you wish. Most of the globally traded financial assets are coded in one of these two legal systems. So it's much more parochial and also much more hegemonic or hierarchical, the global system, than is often depicted. And then, of course, the other question I have to ask, sort of, who's done it? Of course, these are the two global financial centers, London and New York. And then I wanted to show you this. When you think about who are the global law firms, the 100 top global law firms are all located in London and New York, and they all have Anglo-Saxon names. They're either indigenous American or English firms, or they have merged with continental European or Japanese firms. So in countries like Germany or France, most of the work in M&A and capital market law is done by global law firms and not by local law firms any longer. So I'm basically saying, sort of, the masters of the code, right? They don't really like to hear it. The lawyers want to say they're just agents of their clients. They're agents, they're not masters. I'm saying you're masters of the code. You know how to code. You can substitute assets, you can substitute clients, but the coding is what you master, right? And that's the key thing. And this then leaves me with the final question. Yeah, this is this one, we the people. How do we, how should we think about this, right? We have created a system, and this is a longer process of legal evolution and legal institutional change, whereby we have basically given those who are resourceful enough to do so the ability to pick and choose from legal systems, different legal systems, the ones that best suit their clients' needs to advance capital's interest. What they're ultimately doing is they're invoking, right, state power, because that's what you need. But we have created a system that makes it actually very easy for private parties to avail themselves of state power to do their things, but in a way that benefits, of course, mostly their own private wealth interest rather than the common good or the public interest, however you want to call it. And that is in tension with our quest for democratic self-governance. So the more we allow easy opt-outs, or even also easy opt-ins to some extent, because New York and England, I think most of the people in these countries are not aware about the extent to which they are fashioning legal institutions that are globally used to code capital. So the more we allow that, the greater the tension is between a collective sense of governance and the not unilateral, but sort of the invocation of state powers by those who have the greatest sophistication and the best lawyers at their side to do so. So that's I think the dilemma that I suggest we are confronting today, and I have some suggestions at the end of the book how to address this, but maybe let me stop here and just listen to some comments.
Katharina, thank you so very much for the We'll move now to our discussion, but because it's a very busy time in the semester, and I know quite a few people will have to leave the room before 1 o'clock, this is the first of two good opportunities to leave, because we do want to have a good discussion. And if you have to leave within the next 15 minutes, this is the best time. You will get another chance to leave after our discussant is done, but it's good to choose one of those two times just because these chairs make a lot of noise, and we're going to be trying to figure out all of the insights that Professor Pistor has just given us. So now is a good time. or stick around for the next
or to come in.
12 to 15 minutes. And we can switch a few seats around. That's absolutely right. Let me very quickly introduce our very accomplished discussant, Professor Seth Rockman from Brown's History Department. Professor Rockman is an authority on the social history of capitalism in the United States. He was educated at Columbia University as well as UC Davis, and is the author of numerous publications, one of which, his 2009 book, Wage, Labor, Slavery, and Survival in Early Baltimore, received numerous prizes from the historical profession. And without further elaboration, I want to turn the floor over to him. So thank you very much. The floor is yours.
All right, thank you, Nick, and thank you.
We have problems with our cell phones.
Seriously, worse than the students. It's really remarkable. Thank you, Nick. Thank you, Professor Pistor, for sharing your deeply historical work with us. I want to offer you a particularly warm welcome to Rhode Island, a place known for its concerted efforts to break the code of capital while making it possible for debtors, in fact, to convert all of their liabilities into state money at a moment in time about 230 some years ago. I'm referring to the summer of 1786, when the struggling state made an effort to address the brutal shortage of currency by emitting a substantial sum of unbacked paper money, that is to say money that could not be immediately redeemed for specie, and requiring all participants in market exchange to value that paper as equal to silver, and in fact making them obliged to accept it, that is to say making it legal tender for all transactions that would take place in the state of Rhode Island. Moreover, the law made it possible for Rhode Island debtors to use that money to settle debts with out-of-state creditors. If you could not get that Connecticut merchant to take this money directly out of your hand, you could deposit it at a state court in Rhode Island, and that would, for all intents and purposes, mark you as having discharged that debt. This law also included, this legislation also included a force act that meant that there were penalties that would befall any merchant, any private party that refused to accept this money in a private transaction, and also instituted special courts and non-jury trials for the enforcement of this issuance of money. This was, of course, one of the most infamous, if you will, moves by any state government in the decade after the American Revolution. And the law was not particularly long-lasting. It was struck down in a state Supreme Court case, Trevitt versus Wieden, which is usually cited as a precedent in the history of judicial review. But the law was struck down not because there was any problem with the issuance of unbacked paper money, but rather because the lack of jury trials was deemed a violation of rights. But the law, of course, had a much longer life, at least in the imagination of the nation's creditor classes, alarmed and outraged that a state could legislate and enforce the value of a paper currency. The amount of vitriol levied against the state of Rhode Island was really massive. The Massachusetts State Supreme Court Justice Francis Dana declared that Rhode Island should be obliterated or annihilated as a state. A Connecticut lawyer called the state's laws, quote, the most extraordinary laws that ever disgraced the annals of democratical tyranny. And he was not using the term democratical in a good way. He was using it as a bad word to refer to what 18th century commentators would have known as mobocracy. There's certainly reason to believe that the Rhode Island legislation loomed in the imagination of the men who met in Philadelphia in the summer of 1787, and at least here we like to believe that Article 1, Section 10 of the Constitution, prohibiting states from issuing coin money, or from coining money, from emitting bills of credit, making anything but gold and silver coin a tender in the payment of debts, and of course issuing no laws impairing the obligation of contracts, was written with our particular state in mind. But it's also, of course, worth mentioning that the ill feelings were mutual, at least to the extent that Rhode Island refused to ratify the Constitution until well into 1790, and then only in response to the coercive threats of the now fully operational national government. I use this Rhode Island example as an entry point into my wholehearted agreement with the premise of the Code of Capital, and my pleasure with a book that I think readers in my community of scholars, those traveling under the banner of the history of capitalism, will find incredibly convincing and to which they will be fully sympathetic. I want to say a little bit about where that conversation is and how it intersects with Professor Pistor's Code of Capital, but then come to some of the questions that I think emerge from this Rhode Island example, and that meet up with your concluding comments about basically what are the consequences of this for democratic self-governance, and what does the future look like, or is in fact the game over? So within this emerging subfield of the history of capitalism, I mean, there's overwhelming agreement to do exactly what Professor Pistor has done in this book, to describe capital capaciously, to recognize that the terrain of conflict is as much over the means of payment as the means of production, to recognize that the processes of commodification and financialization that move more and more, make more of the world bendable and make more of the world available as a kind of hedge, that these processes require work, and they must be studied not as the outcome of inexorable market forces, but have to be understood as the outcomes of power, and the operations of power that allow for some things to be moved into the market, right? That transition of land, for instance, from being protected under entail into operating under fee simple transactions, but also to move certain things out of the market through legal codes or legal fictions like the trust, but also through the regulatory operation of states through such things as slave emancipation. And I think it's important here to recognize that for most of the history that leads us to this moment, human beings are property, which is something that the book acknowledges, but to think about the emancipation of, for instance, the most important asset class in the 19th century United States, not as the result of simply efficiencies that the market provided, but as a massive mode of state operation in which ultimately it is law and the violence of the Union Army that brings about this outcome. Likewise, in this sort of conversation between the history of capitalism and the code of capital, there's clearly a shared set of commitments to what many people in the discipline of economics might identify as the new institutional economics, right? A focus on the formal and informal rules that organize and structure exchange. But here I think Professor Pistor does something very interesting that is exactly what a historian of capitalism would do departing from the economist, which is to say that these rules in particular are not meant in the anodyne way of simply reducing transaction costs, but actually are fundamental to the operations of power. And they are a mode of ruling rather than simply a means of creating new efficiencies to smooth transactions. Additionally, within the field of the history of capitalism, there's a lot of attention to lawyers as, in fact, being the crucial class of actors, those who the historian Charles Sellers, in the context of the 19th century United States, refers to as the shock troops of capitalism, a group that in particular made its own form of expertise, that is to say, knowledge of the law, a prerequisite for lawmaking itself as they came to dominate state legislatures. Lawyers became the most prevalent occupation of state legislators in the United States in the 1820s, 1830s, and 1840s, basically making lawyers and lawmaking redundant in the legislative branch, not to mention, of course, in the judicial branch. And of course, within my field, there's an abiding commitment to the work of someone like Morton Horowitz, focusing on the ways in which the story of capitalism is largely run through the developmental bias of the law, through an instrumental jurisprudence that's fundamentally using the law as a technology to promote developmental economics and to move an increasing amount of the law out of the realm of democratic adjudication into the realm of unelected courts, and particularly in the courts itself, moving certain kinds of disputes out of the realm of juried spaces into spaces of equity courts or chancellery courts that empower judges and judges alone to decide what's actually going on. In this sense, too, thinking about the ways in which, as the Code of Capital refers to, when things are encoded in the law, and when capital is encoded in the law, it allows for bad behavior because it's legal. And the constant recourse to, but it's legal, as a way for allowing inequalities to emerge and to sort of self-perpetuate is, of course, very much part of this thinking that somewhere in the 19th century we move from a judicial system that is invested in notions of community fairness and creates space for communities to decide this, what is often referred to, as an equitable conception of law, into one that is much more interested in sort of a will theory of contract, in which if two parties agree to it, it's all good if they have in fact agreed to it. Most of all, what we all agree to is the idea that there is no capitalism in practice outside of the state. There is no capitalism outside of the regulatory regimes that the states establish, the contract enforcement mechanisms that it creates, its capacity to declare legal tender, and not to mention, of course, the operations of and indispensability of its military capacity to dispossess lands, to police shipping lanes, and to open markets in distant parts of the world. In some ways, then, the state and the market are, in fact, coterminous spaces. This may not be true in theory, and I know many people dismiss this in theory, but in practice, in history, we don't have many examples other than this being true. I was once accused of being so much of a historian that I kept saying things that were contextually true but economically implausible. I'm willing to have that, inscribed on my tombstone if it comes down to it. But the questions that I want to sort of lead to from this conversation is about what happens when we collapse the boundary of the political and economic. Right, and thinking about sort of if in fact the state and the capital are entwined, if the state and capital are entwined with one another, is it possible to think about one is the dog and one is the tail, and to try to figure out who's wagging who, right? And that's not necessarily obvious here in the way that I read this book, and this is one of the things I'd like to hear you speak a little bit more about. Are we talking about a process of administrative capture by which a cohort of actors we call capitalists have taken over the means of producing law and in fact the administrative components of the state to create regimes that privilege them over the majority of people? Alternatively, though, there is a body of scholarship that certainly is historical that's thinking about the ways in which the state, in fact, makes itself. The state is, in fact, produced through its organization of the economy, and that if we want to think about not simply capital mobilizing the state, but rather the state mobilizing capital as a way to create its sovereignty, to set the boundaries on its territory, to create the allegiance of its people. And certainly this comes through the work of a legal scholar like Christine Desan, thinking about basically the engineering and architecture of monetary regimes as the fundamental way by which the modern nation state creates its sovereignty. To create its money and have its money matter is the way in which states become real, particularly as you move into societies that are not going to be held together by shared religion or even held together by adherence to some set of hereditary monarchs, but rather in which the market will be the fundamental determinant of who belongs. So thinking about the ways in which sort of the state and capital are bound to one another, and thinking about if in fact we want to say that these are the same entities with shared goals, or if this is in fact kind of a mutual beneficial relationship in which each group is getting something out of the other. But I want to think about whether it's important to think about the way that states have an investment in capital and the code of capital, just as much as the code of capital or the capitalists have an investment in the state as the fundamental mechanism that they have for making the world safe for investment. But the second thing, and this is perhaps the more important thing, right, where this culminates is, okay, what are we going to do about this, right? And what are the possibilities for making law in a democratic society? Obviously, in the legal regime that we're living in today, we recognize that, in fact, law is made in multiple places. And in particular, we have spaces where presumably the people are empowered to make law, and these are called legislatures. And we have a realm of unelected officials in most places where the law is determined whether or not it's valid, and that is the judicial branch. And we know over time that certain things come to be understood in the purview of one, and certain things come to be understood in the purview of others, and this has not been consistent. We know in the early 19th century, for instance, that an increasing amount of decision-making around private property and land and about developmental rights of, say, using a river to power a mill versus using a river to irrigate a field, that this moves out of the realm of the legislatures into the realms of judicial lawmaking, and this is quite important. Alternatively, we know that in the realm of labor law, things that in the United States that had been organized around feudal conceptions and decided almost exclusively by judges in private places, become by the 20th century the realm of legislatures. And this is, of course, Karen Oren's argument in Belated Feudalism, a book now, 30-some years old, but which continues to have hold, I think, in the American political development tradition, and that recognizes that there's no unidirectional relationship between sort of things always under the Code of Capital moving from available to the people to decide on into the realm of this very limited and arguably the least democratic branch of American governance. So we know also from history that, at different times, different places, state legislatures have passed lien laws to prioritize certain creditors over others, and these have been enforceable, that people have in fact attempted to create new kinds of financial regulation again and again and again, and sometimes these are upheld by courts and sometimes they're not. But I think it opens up a set of questions for us about where we want the law to be made and about what are the prospects in the future for using the sort of democratic resources that are part of the American constitutional structure to in fact make laws that serve the many as opposed to those that reinforce the power of the few. And so is there a hope, for instance, that the state legislatures, just as they were the crucial sites of making the Code of Capital in the United States in the 19th century, could be in fact the crucial sites for unmaking the Code of Capital in the 21st? And that's a question that I leave to you and that I hope we can all think about a little bit more in the future. But thank you.
Seth, thank you very much for a terrific set of comments. I think now is another good time to leave for anybody who has to. We should, I think, turn it over to you, Katharina, if you'd like to make some replies, and then we'll open it up for Q&A.
Yeah, so first of all, thank you very, very much. This is terrific. I sometimes say I'm a closeted historian, but I'm not a real historian. So I've always studied some history on the side, but I never got my full degree. But I love to engage with that, and so I really appreciate your very comprehensive treatment of these issues. So I think the fundamental dilemma that you point to is sort of what is actually the relationship between the codes of capital, sort of the law, and then state power, and how are they meshed. And I think you're probably right in sort of discerning something that that I don't really stand fully behind, that there seems to be an argument or a thread in the book that says it's gotten worse and worse and worse, and it's a little bit unidirectional. And I think that I take that critique. I don't think that's actually entirely true. I think there are different ways in which these things are configured, which makes sort of the answer to the question at the end. So what shall we do about this really complicated? Because law is made in multiple places, and it's always been made in multiple places, and it shifts for different types of things. And one of the issues that I find really disconcerting, especially in our world of global finance, is that we're not even going to the courts anymore, right? So we don't want to have legislature. Regulation we need regulation sometimes to get real clarity, but we're trying to get away from that. We don't want to have courts anymore, because the worst thing that you could have if you create a global capital system on the basis of English contract law and you get a precedent by English court, the whole thing blows up. So even though the common law courts were so important to create the system in the first place, they're the last ones that you want to call on right now, at least from the point of view of the coders, to get in. So we're basically building a system that is increasingly attenuated to the source of its power, because law firms are writing legal opinions to say you can do this, and we interpreting decisions that are now 10, 15 years old, because we're not getting any new ones. We really don't want any new ones either. So this is funny relationship. But this doesn't mean that we don't have other entry points. And of course, at some level, if you take this argument to its conclusion, you say, well, it's hopeless anyway, because it's the state is the power. The state wants to have capital, so it will enable it, and capitalists want to have the state to enable themselves. So it's all circular. But I think the beauty of a democratic system is that we can try to harness state power in a different way. It's not the one thing. It's not a single actor, the state, right? So, and I just like to think of it as a more fluid set of, sort of a particular institutionalization of coercive powers, and this is basically the law, and it can be used in different ways. Your Rhode Island example suggested, and I think more could be done today. I don't talk so much about the federalist system in the United States at the end, but I do say at the end that globally speaking, individual states, sovereign states, should basically think about their legal sovereignty and take it back in their hands and use it. And that means basically rolling back sort of the outsourcing that they had made so easy through conflict of law rules, basic choice of law, or private arbitration that the courts will nonetheless enforce, and through more imaginative law making. That, of course, always gets the counter argument through regulatory competition. This will erode again, but I think there is more that individual states could do. And so in that sense, I would say yes, I think individual states in the US could do something. They can't do everything. There's still the Commerce Clause. There's still sort of the enforcement of you have to open your territories to everyone. But I think they could probably do more than they're currently doing. I think that's the space, at least, that I see sovereign states or states within the United States where pushback can happen. But let's open it maybe to Q&A more generally.
Terrific. Let's then open the floor to Q&A, and if people could identify themselves when asking questions. Should we take two at a time, do you think?
Oh, three, yeah, that's
Great.
fine.
Yes.
Jay, practicing attorney, one of those firms that was on your list. Just wanted to add a footnote, but also to leave it as kind of a question. Law is generally reactive, I think. You've pointed out that frequently there's a problem and it takes one country 300 years to deal with it, and in another place they can deal with it much more promptly. China. Those firms all have teeny little offices in China. There are huge offices in Hong Kong and in Singapore. And the reason for it is the one that you were indicating, which is they have not reached a point in China where they're comfortable with, should we call it, the horizontal contractual deal making. That is historically going to become very relevant because it is becoming such a huge economy that it's going to be able to move a lot of weight in the world. It's not clear that they're going to play according to this rule. So all of this discussion has been premised on, well, what are we going to do about it in our democratic society? It may be that there's a different mode of governance which is going to be powerful enough, and it's going to have the votes to enforce its will. That's going to take a very different view. And that may alter a lot of what we're seeing. Flip side, I love the title and the cover of your book because there's the nod to coding and artificial intelligence. We have the private sector in this country wanting to create its own money, which, I loved your phrase, and I'm going to get it wrong, but it strikes me as economically plausible, but contextually ridiculous. It's hard to conceive of governments in this country giving up their power over money, if money makes them real, to Mr. Zuckerberg or anybody else. But you have these two forces coming, which was meant to be the observations. And then to ask the question, which is, how are we the people as reactive? Because that's what we are. We react to things. We're not ahead of this. How do we deal with it as those big forces roll in on us from our inside domestic forces, Mr. Zuckerberg and Google and all those people, and the outside?
Great. Take one more? Terrific. Well, now we've got a lot of people on the list, so we'll have to keep our questions fairly short, but I think you were next.
Yeah, I have a question from another angle, so to say. There was a debate in the 90s, yeah, since 1989, one can even say, about global constitutionalism, yeah, and global law. And then was also a little later a debate, became ever more publications, yeah. And later was a debate on private international law, not international law, but private transnational, post-national law based on the self-organizing power of legal system was not mostly from German lawyers, but from some lawyers like Teubner and that school, yeah, and so now the problem of all these things was the question of enforcement, yeah, I found it very interesting, as you said, well, there is no global law, but there is domestic law, yeah, and there is still domestic law that is global, and that is the law of the state of New York and the law of England, yeah, which also was observed at that time, but not in the center of the debate. This is, so to say, the center. And that I find very interesting because the people, yeah. So once this this common law, yeah, this sort of common law becomes global and enforceable, but on the state basis, it is finally totally decoupled from democratic legislators, yeah. And this total decoupling in the state already it was an imbalance, yeah. Which one can nicely see throughout the 19th century. Yeah? But now this is totally decoupled. And the question is, yeah, well, and that solves also the question why the European Union is as it is, yeah, an anti-democratic monster, so to say. Yeah? So, but what to do? What can one do to get the people back in the boat?
Okay, so that's a big stretch of territory from China to the EU, and then we don't want to lose sight of democratic openings at lower levels of aggregation. I leave it to you.
Thank you. So China and the digital currencies, these are really, really important issues. And I think we agree that just the threat of this shouldn't sort of, move us away from the critique of our own system. But I think these are fundamental challenges. And I exactly agree with you. China has never embraced the horizontal dimension of law. That's something that they're still uneasy about. Having said that, we do see an emergent shadow banking system in China as well. We just have too many LLMs that come our way, and they get trained, and they also practice here long enough that they can bring some of these elements into China, but the state is really trying to retain control. And that particular form of state control of how we organize our lives is not necessarily the one that we want to have, right? So there's got to be a normative debate here, and I want to have this normative debate. I mean, one of the reasons for writing the book is to say how much flexibility and should we have and give people, because that's also, it creates vibrancy, it creates a certain degree of self-authorship, but of course more for some than for others. The real threat for me is the digital, and I think China has already learned how to master the digital control in a way. So it's not the free space that it once was, WeChat, but I think the government is basically controlling the digital space, including the digital currency space, and the combination makes me really, really uneasy. But I was also very uneasy, I'm still very uneasy about Libra and similar things. When the Libra came out, I wrote a big op-ed about this because I just felt that's just taking it too far. Now you're basically tackling monetary sovereignty. But this is coming, and states will not want to give it away, but it's not clear what individual states can really do about it, right? If they have a Swiss association and they buy US assets to back their reserves, there's nothing really the government can do about it in the United States. What they can do is they can tell MasterCard and Visa that they can't participate, and they can say you can't issue in the United States, right? That they can probably do, or we regulate it as a security or something. But other than that, by exploiting again the multi-jurisdictions in the global sphere, the ability of any individual government to really control the beast is rather limited. And so we would need more coordination of governments. Of course, coordination between governments in this moment, in this political moment, is more difficult than ever. So that's a true dilemma. So what do we as the people have to do about this? I think we do still have the only path that I can see is really we have to mobilize our lawmakers, legislators at the local or the federal level to take things back into their own hand, to create a viable alternative to a Libra, right? And to think about new ways of harnessing this technology for things that are socially desirable. But it's of course an uphill struggle. I realize as much, but you have to have some hope here. global constitutional, I sort of, I've followed sort of the debates about global governance and global constitutionalism since I come from the private law side and I teach corporate and finance. I've always been a little bit amused about how much weight was given to that while totally ignoring the extent. He has written a little bit about that. Yeah, I know. He has. So, and I think sort of, I want to just link your argument about the decoupling from the state, which I have some of that flavor in my book too, back to what Seth said. It's actually most states have, of course, agreed to that decoupling for some reasons, and some of them just do this to promote their own companies that are foreign investors elsewhere. Think about how where the bilateral investment treaties originated when the multilateral agreement broke down. So we just give bilateral investment treaties, but there are states on the other side that sign up to this too, in the hope that they can attract capital to their shores, right? So the conflict of law rules, private international law, and some of the bilateral investment treaties that make this possible and give investors additional protection in the law always require states to participate in that. They're always complicit. So in that sense, it's always this symbiotic relationship. You really can't get away from that. So you have to shift the debate within states. I'm not saying they couldn't do differently. They could, and I think some of this is just ideology, and but there's no silver bullet where you could say, well, now we have the state back and fine, right? Because these are debates that we have to have continuously. On the EU, we can have, maybe I'm just not going to say too much about this. I think the EU is sort of somewhat undemocratic. I still think it's more democratic than the private ordering that we've got. So it's the one entity that can actually give pushback on state. Yeah, exactly, yeah.
Great, so now we've got a longer list, and I think Chase, you were first. Why don't you identify yourself and ask your question? Then I have Tony Balanos, then over here.
Sure. I'm Chase Foster. I'm a postdoctoral fellow at the Lutz Institute. So my question is kind of related to these previous questions, which is where do you see the most meaningful variation? Right? And the book is really nice in the sense that it points to a lot of the commonalities across systems and the convergence, but along which dimensions of law today do we see the most meaningful differences with real impacts potentially on inequality? So, you mentioned maybe civil and common law distinctions about contract law and the trust law, perhaps on intellectual property rights in the EU and US, perhaps in other dimensions. Where do you think we see real differences?
Yeah. Well, I think it would have been easier to answer this question like 4 decades ago. I mean, nowadays many more things have not fully converged. I'm not sort of a believer in convergence, but they have been transposed and mixed in such a way that it's harder to identify that, right? So the EU introduces basically the incorporation theory for corporations, and basically does something that the US had done already in the 19th century, but introduces this into its own regime only in the late 1990s. But once it has done that, people can pick and choose the law for their corporation, and therefore can also pick and choose other laws. So it becomes more flexible. I think the shift towards private autonomy, free choice, has been very strong. China is sort of the one big player that is basically saying you can't really do this entirely, although they also have their own, of course, interesting partnership with important private actors. One of my colleagues at Columbia, an Italian who just joined us, basically said, there's still a difference between the civil law and the common law system to some extent about how we police the boundary, so the way he puts it in a very legalistic fashion, the boundary of the numerous clauses. And the numerous clause basically says there are certain types of interests that the state decides it will protect as property and basically give this universality to, and others it just won't. So you can do this, it's not illegal to do things, but you just can't bank on the state enforcing your claims against the world. And the civil law system has always insisted the state defines what these interests are, and you can't just simply blur the lines. And the trust is, of course, the most important institution that shows how you can blur the line. And I think sort of by and large, civil law systems are still more likely to do that, but since they have opened their borders for common law entities, institutions to come in through choice of law, you can't really say it's fundamentally different, because if they can't do this in German law, they can just bring the English law in and do the same stuff. because you can deterritorialize these institutions through the conflict of law rules, right? So this brings me again also back to what to do about this. Well, maybe we should limit the options that people have to choose different laws and bring them back in, right? Maybe you should just not be able to go and shop for law. It's not a private commodity. It is a social good, and maybe we should govern it as such.
Great. Tony Levitas, and then a question from here. We'll go back to grouping then.
I'm sorry, yes.
Thank you for a fascinating talk and a really wonderful comment. And let me see if I can get out my question simple enough to ask this second. But, there's an incredibly paradoxical outcome that global capital has coders in specific zip codes in cities, in some sense, who exist in a completely sub-sovereign setting in one way. And I'm wondering, and your argument almost is that this has been coming out of these zip codes for a long time, on the one hand, and then on the other hand, it seems like a lot of the story could be about the particular regime of horizontal law that has been around for 30 years, I don't know, call it the neoliberal regime if you want, and that the hierarchy of laws that we're talking about, which you've been stressing, the citizen-to-citizen law, has moved up, whereas other aspects of this have been displaced. So I don't know, in that typology of law, where would you put tax law, which again affects all these players and is the direct exertion of the state on these forces? And are we really saying that the masters of the universe are sitting in 15 jurisdictions and writing the code for the world? And have been doing this for a long time, I guess, those are the two.
Great question. Another question, yes.
My name is Tom Seguros. I'm research faculty in computer science, but spend a lot of time on public finance issues too. I guess my question are a little more mundane, having to do with how these things manifest in my life and the way that I perceive things. One of the stories that I've noticed but don't really understand the underpinnings of is how, when I was little, a Swiss bank account was an exotic and unusual thing, and now you can call up a bank and ask to speak to their offshore banking department. And I wish that I had a pointer to a detailed story of how that evolution happened. And so, because I don't think there was a moment. I think it was an evolution of understanding and interpretation and things like that. And again, my question's a little more mundane. I just wonder if you're aware of compelling accounts of how these things sort of manifest.
Answer? Okay, so thank you. So, I think the localization of the master coders has a long trajectory, and it has something to do, I didn't talk about this in my talk, but if you look at the organization of the private legal profession, that's where you see actually a fundamental difference historically between different legal systems. So England developed a very robust legal profession already started in the 13th, 14th century, and they serve private clients. They don't just work for the crown or for monarchs or for a court of law, but they work for private clients. And Prussia halves its private legal profession in the 18th century and then imposes rules that you have to have certain education and certain status to be able to present a client in court. So they don't want to have these freewheeling lawyers, right? The US is on the other extreme. It doesn't even have rules for how you become a lawyer really until the late 19th century. And nonetheless, people described the US as a deeply legal, lawyerly type of legal society. Or at the beginning of the 18th century, well, the state was far, but you still needed to decide where the boundaries were and create property rights, and the private lawyers did a lot of that. So I think when you look at the organization of the private legal profession, I think that's where also, to me, increasingly the real difference lies between the common law and the civil law, with some doctrinal stuff put on top of that, but it's important. And that also enables the use of the horizontal law, because if you know how to use that and you build a powerful practice, you also of course gain influence then again over the state, how to shape the law such that you have the flexibilities to do so. This is again sort of this interaction. Tax law is sort of, at first glance, of course, this hierarchical top-down. It's always the most hierarchical top-down. But tax law and usury rules, anti-usury rules, were actually what's the stuff where the lawyers have honed their skills for centuries. They always tried to get around this. So the predecessor of the trust I talked about earlier was the use, which was invented in the 12th century. And in 1485, I don't remember which king in England it was, but he enacted the Statute of the Use, where he was trying to outlaw the use because it was used particularly to avoid taxes. And then the lawyers reinvented the trust. So if you can get around taxes, and nowadays, of course, Cayman Islands and all the other tax havens. So in that sense, it's a mix. The tax authorities try to tax, but you use the horizontal law, which states enforce, to get around it. So one argument I make in the book is that, I don't see why we only sort of blacklist countries like the Cayman Islands as tax havens. Why countries don't simply say, we will simply disregard your corporate identity. We just disregard this as a legal person and tax the assets nonetheless, because this is clearly just a shell to try to get around taxes. They're hesitant to do this because they want to maintain the fiction of a legal personality, and there are powerful interests that want to do that. But that's where I want to push back. Say, we just have to go back to the normative principles under which you can avail yourself of the state's powers by using these forms. So I can't give you a reference on how this all happens, but sort of just, I think this has a lot to do with, especially in the post-World War II area, with sort of the history of how we opened the world for free capital flow, right? So after World War II in the Bretton Woods system, you had very restrictive capital flows, and it was much more difficult to find ways to have a legal bank account elsewhere. And I think that was sort of broken down step by step, and you can just walk through the motions of doing that, and so I think these were, and I think at each of these steps you can see how different interest groups, of course, they start very often also again by arbitraging around capital controls through foreign exchange swaps, right? It's not that hard to get around this, and once you have that and you make a powerful case to one of the legislatures, say, we do it anyhow, you might as well legalize it, then you legalize it in one country and you push the same thing to the next. I would have to think about whether there's a really good historical account of that, but I would locate it in this period, post-World War II.
Great. Can we take one more question if there is one, and then we'll let you have a couple of slices of pizza. So, fine. Yes, one more question.
Yeah, my name is Tom Slade. I'm a retired management consultant. I want to go to something you and Jack have both commented on, and that is the reactive nature of our coding. I once heard a few years ago, I heard a professor from the French law school give a talk about how the legislature has done there, and that, here in America, we give the legislatures a chance to make the law and make as many mistakes as they want, and then we litigate it afterwards when disputes come up. And he was describing a situation that sounded something like the Congressional Budget Office or something, that there had to be an evaluation of the impact of a law before it could be completely enacted, which seemed kind of logical to me. I don't know how effective it's been, but are there other, has that been effective? Are there other ways that we can make the coding less reactive, I guess?
Yeah, I think the coding. So I use the word coding basically for the process by which private attorneys sort of combine these different legal tools to create a new capital asset. So I'm thinking about software coding or genetic coding. I think what you're talking about is more like the codification, the top-down legislation. So what is interesting about the French case is that basically with the French Revolution, they decided, so we've had enough of this close collusion of judges and the state. And so they ruled that judges cannot make law, they can only interpret law, right? So they don't have this power anymore, only the parliament can make law. They even denied judges judicial review because they said, it's the legislature that makes it. And so until Sarkozy introduced these reforms in 2007, they did not have a constitutional review of legislation. And then they changed it. And so what they did is basically once a bill came through, they would basically do a pre-enactment constitutional assessment. Now, it's not really cost-benefit like we do many of these laws here in this country. What might be the negative effects on commerce is the question that people ask here. But there was basically the constitutional of that. And, I think the fact that they ultimately introduced judicial review tells you that it probably wasn't doing its job entirely. It's very difficult, to be fair, to anticipate what a law will accomplish, right? Laws are incomplete, even more incomplete than contracts are. The world changes. You want to write laws that last forever, but the world around you changes. And so a complete reliance on ex ante review just has to be bounded, so it's not entirely effective. But what remains true in France nonetheless is there's still this ideal that you have a legislature that can fix it. So I talked about my book in Europe. I was traveling last week, and in Europe, Belgium, and also in Paris earlier, people still feel that there's got to be a legislator that can fix it all. Are perhaps also less exposed to the extent to which private...
Theory, yes.
In theory, yes, yeah. But they also have to see how with what the mobility and the malleability of the law that exists in those countries today as well.
Terrific. Well, I think we've learned a lot about just how important law is and how much it can change in highly significant ways without our necessarily noticing. All from our speaker, and thanks also to our discussant for reminding us that we do have to think about how we can exercise some control over these changes that are happening with really great consequence. So thanks everybody for coming. Thanks especially to Katharina Pistor.